Good night, teacher. My name is Doris Quiñones. Our group is made of four students, María Menguán, Andrés Vega, and Paola Gordillo. We study at the Fundación Universitaria de Compensar, Business Administration, and Public Accounting. We are from different semesters in virtual mode. We have answered to the two cases raised the teacher. Case 1. First case. Jose works in the business area of the company, and he has lowered sales company to all his partners. How so will the company proceed so as not to the main decimal with case? Answer. To carry out the decimal with use cause do the breast of contact be the worker, the employer must send a document or letter to the worker. A controller identify the cause of rising for the decimal, and if application, presentation, the respective evidence. The facts and circumstances move be specific in the communication indicating of modalities of time, place and condition. In case of determining to need determine the employee contract, the employer move made the respective settlement payments and of payments hour. Good night.
Hello, my name is Catherine. I am going to talk about legal analysis. In Colombia, the labor code regulates dismissal with an just cause. According to Article 62 of the Labor Code, the ground for dismissal with just cause are established such as the employee low performance, as long as it is duly proven. In Jose case, if is low performance is the reason for the dismissal, the company must ensure that it properly documents evaluation of this performance, as well as demonstrate that measures have been taken to improve his performance before proceeding with the dismissal. In the dismissal carried out with just case, the company will have to compensate him according to the provisions of Article 64 of the Labor Code, which establish compensation parameters depending of the type of contract and the time Jose has been working for the company. Thank you.
Okay. Laura is pregnant and facing a complicated situation. After a violent incident at work, her dismissal has been justified with inappropriate behavior during an argument. There are laws that protect pregnant workers from unjust dismissals. It is crucial for Laura to inform herself about her rights, as a dismissals related to their pregnancy could be considered discriminatory. Just case, Laura is a dismissal is a based on violent behavior, which can be a valid reason for termination. However, it is important as whether she was given due process and mitigating factors were considered. Emotional impact. Pregnancy can affect a person's emotional state. Laura should recognize that while her behavior is inappropriate, there are factors that might have influenced her reaction. Lo dije.
Hello, my name is Andres Vega and I'm going to talk about the second case. So, to advise Laura based on Colombian labor law and relevant jurisprudence, here are some key points that should be considered. First, special labor protection for pregnant women. In Colombia, pregnant women enjoy a special protection under labor law, known as estabilidad laboral reforzada, reinforcement labor stability. This means that Laura cannot be dismissed without prior authorization from the Ministry of Labor, even if there is a valid reason such as a misconduct, as described in this case. This protection is established in the Article 239 of the Colombian Labor Code and reinforced by several Constitution Court rulings. Second, due process and disciplinary actions. While Laura's pregnancy grants her protection, it does not exempt her from being subject to disciplinary actions for misconduct. However, the employer must follow the proper procedure, which includes obtaining permission from the Ministry of Labor before proceeding with any dismissal. Failure to do so will make the termination invalid. Third, legitimate just case for dismissal. According to Colombian law, acts of physical aggression in the workplace can be considered just case for termination. Laura's violent behavior could fall under Article 62 of the Colombian Labor Code, which outlines reasons for termination with just case, including violent conduct against co-workers. Fourth, jurisprudence on pregnant workers. The Constitutional Court has consistently ruled that pregnant workers can only be dismissed with just case and always with prior authorization from the Ministry of Labor. In rulings such as C-629 of 2010, the court emphasized the importance of protecting pregnant women, but also highlighting that such protection does not allow impunity for acts of serious misconduct. Advice to Laura: challenge the dismissal. Since the employer did not seek authorization from the Ministry of Labor before terminating Laura, the dismissal could be challenged as unlawful. Laura can file a complaint with the Ministry of Labor to contest the dismissal and request reinstatement. Acknowledge misconduct. Laura should also be aware that, despite the protection of her pregnancy, her actions could lead to disciplinary consequences. It is important for her to approach the situation responsibly, acknowledging her behavior while defending her right to due process and protect under the law. In conclusion, Laura's dismissal is like unlawful due to the lack of the authorization from the Ministry of Labor. However, her actions may still result in eventual consequence.